A senior advocate who criticizes the senior designation system, an active member and former president of the Gujarat High Court Advocates Association, author of multiple books. Today, we have with us Mr. Asim Pandya, who has now written a memoir of sorts, curiously titled My Misadventures and Failures, and in parenthesis, Laugh Out Loud. The book starts quite literally with the story of his birth and ends at the most recent developments in his life and career. It goes through in particular detail through the highs and lows of a career in law as a young, struggling lawyer to a now an outspoken and indispensable member of the bar. Mr. Pandya, welcome and thank you for being here.
Thank you very much, please.
So, right from the beginning of your legal career, you speak about your struggles on surviving on little to no salary and no stipend as a junior advocate, while simultaneously having to sail through affluent society. Has the situation changed at all for young lawyers now, in your opinion?
I don't think so. Today also, most of the seniors retain juniors, but they pay very bigger stipend to them. To that extent has not improved. But now youngsters are very smart. They rely on AI, they rely on the web platforms, internet, and they, some way, one way or the other, they do advertisement for themselves and then they get work directly, not through seniors.
Right. In particular, in your book, you speak very fondly of your time as a junior to Mr. S.I. Nanavati.
Right.
And you speak very fondly of the practices he adopted, especially in terms of how he treated his juniors. What of his practices have you adopted in your life with your juniors?
Actually, see, he is a generous person and he would pay highest salary to his juniors. He would see to it that his junior must possess car and they should have status in the society. And while traveling to Delhi or Bombay, he would see to it that if we are traveling with him, we will also travel with him in business class. So he will not send us to economic class. So those things of Mr. S.I. Nanavati needs to be imbibed by the many seniors that they should endeavor to pay highest amount to the juniors and try to see that their status is elevated in society.
Right. After your work with Mr. S.I. Nanavati, you started a partnership with Vijay Patel, who was an active politician and later a member of parliament and then a member of the Gujarat Legislative Assembly. How did your association with a politician and with politics, distantly with politics through this, impact your career? Because in one specific spot in the book, you say, unless you are politically strong or have good relations with the persons or bureaucrats in power, you do not get any government posts.
That's right. Absolutely right. In fact, I have written in my book that when I was junior, I wanted to become assistant government pleader. And for that, I had made lots of struggle. I approached the highest authority, like chief minister to somebody, to recommend my name as assistant government pleader, but that did not happen. But as soon as I joined Mr. Vijay Patel, who was at that time member of parliament and later on he became MLA. And in those days, in the state of Gujarat, there was a government of BJP. And for some time also, about 1 or 2 years, there was a government in center also. So my association with Mr. Vijay Patel immediately resulted in giving me or conferring the status of Central Government Standing Council. So if I was independent, if nobody was there, nobody was willing to make me even assistant government pleader. But as soon as I entered the league of these powerful persons, immediately it came to me. And even I have never coveted for it.
Right.
But Mr. Giri Travel was at that time Solicitor General, and he asked that who do you think that they are good person to assist the central government cases? And my name was immediately sent and it was approved by the central government. So I remained Central Government Standing Council for about 6 years from 1998 to 2004.
Okay. You were once considered for judgeship as well. but the recommendation of the High Court collegium did not result in the desired outcome. What do you think were the factors that affected the series of events?
It's a very interesting thing. Actually, when my name was recommended in 2009 for the High Court judgeship, there was a Bharatiya Janata government at state level, but at the central level, it was a coalition government of the Congress. So when my name was recommended, I think there were other six persons whose name were also recommended. One of them is right now in Supreme Court. He is a Supreme Court judge. One or two judges have retired as a Chief Justice of various high courts. So out of these eight names that were recommended, later on, even other eight names from subordinate judiciary were also included. So in those days, since as I said that there was a BJP government at state level and central government, Congress government at central level, there was a conflict that who should be recommended. So ultimately, when the collegium sent eight names, only those two names were cleared who had good affiliation with the Congress government.
Right.
And those I was branded as BJP candidate, though my father belonged to Congress government. My father was active politician in the Congress regime. He had contested election somewhere in 1974 from Congress.
But
But merely because I was a professional partner to Mr. Vijay Patel, probably a show was made that I belong to a particular political philosophy. And therefore, if I were made a judge, possibly it would not serve the public good. And that is how my name was omitted. And only those two names who had good contact with the Congress government, their names were cleared. So out of eight, only two persons were cleared.
At the time, I remember you had filed a petition seeking the details of why why the recommendation of your name was rejected. What came of that case?
Actually, after this omission of my name, I worked and researched for about 6 months. I examined the judgments on this issue, starting from SP Gupta and then first judge's case, second judge's case, and presidential reference. And I tried to find out that what could be done to improve the collegium system and whether collegium system has a constitutional backing, because the language is very clear, constitutional language, that it is the Chief Justice who is to recommend and his opinion matters in the matter of appointment of judges. But then after reading all these judgment, I found out that there are certain things which could be improved. Like persons whose name have been omitted, they should be at least be made aware of what reasons had weighed with the government or the collegium. And secondly, that person must have a right, because right of information is a fundamental right. So I should have at least knowledge. There should be at least an intimation, because we are invited. It is not by filing an application, somebody is appointed as a judge. A person like Chief Justice of a particular High Court invites him to become a judge. And when that recommendation does not result into appointment, at least there has to be a courtesy letter from the central government or the collegium that we regret to inform you that your appointment has not been in for following reason. If somebody wants, it should not be made in public domain. What has been done in the recent past, that the collegium's resolutions are made in public domain. They are published on the website. That is also another extreme. My suggestion is that if somebody wants, like a person like me, I was confident that there was no reason barring that I was branded as a BJP candidate. So I was confident that therefore I said that I should be made aware of the reasons that had weighed with the government or the collegium for not appointing me. And to know the reasons is a fundamental right. So, and this system, there is in presidential reference, there is a system which has been evolved that in a given case, if there is an adverse material against a candidate recommended, he should be at least called and his explanation should be sought for. Because every court is talking about principle of natural justice in even administrative action. But while making appointment, that principle is being violated by the Supreme Court and the High Court, and that is not in consonance with the constitutional ethos. So I was of the firm view that at least there has to be some reasons assigned to the person concerned. It should not be published in the public domain.
Other factors notwithstanding, would you give consent for judgeship now?
Now I'm almost 60, so there is no fun in doing that. After my recommendation in 2009, after unsuccessfully challenging the system, I was not seeking appointment, but I was more concerned with bringing reforms in the collegium system or appointment system. But since thereafter also one or two chief justices called me, but they were briefed that I am a person who had once upon challenged the system and challenge non-appointment, and therefore the chief justices regretted that though we have in our mind your name or again recommendation, but we would not like to recommend for this reason. So those things have been told to me in person by certain chief justices.
In other parts of the book, also, it's quite clear that you do have criticisms of the collegium system as a whole. In one chapter, you, without naming names, draw attention to the case of Justice M.R. Shah, I'm assuming, who was elevated to the Supreme Court out of order instead of being transferred to another high court, as was recommended. What changes do you hope to see in the system to prevent such cases?
It's a very good question, but the answer is very difficult. I have already made suggestions by writing an article on one law journal also, suggesting improvement in collegium system, how it can be improved, because now it has become part of our constitution. National Judicial Commission, that amendment has been struck down, being unconstitutional. So now we will have to live with this current system of collegium, and therefore one has to think of reforms. And now I think one important thing that has happened is that those candidates whose names are recommended, they are called for at least personal interaction, not for personal interview. So I think that's a welcome step. And during that interaction, the judges of the Honorable Supreme Court can at least judge what kind of person he is, what is his background, or something of that sort. And during that interaction, if some adverse material is there, I think that it's ideal that a person should be posted with that adverse material, and his explanation should be sought for. That is contemplated in the presidential reference case. So if that is provided for, it is good. And I am also on the issue that the decision of the collegium should be justiciable. It should be subject to judicial review, because however you may be high in the position, but judicial review is part of basic structure of the constitution. And merely because the appointing authority is Supreme Court or judges of the Supreme Court does not exclude the basic structure doctrine of judicial review. So if it is made justiciable, today the situation is that only eligibility is subject to judicial review. Suitability is not subject to judicial review. Now, eligibility was always from the beginning, because writ of quo warranto is always that somebody who is not authorized or who is not competent to hold office. So eligibility, you are not saying anything new. Suitability, most of the criteria of suitability are also objective, and therefore they can also be subjectively, they can be reviewed, judicially reviewed, like income criterion, then how many cases you have handled in your career, how many judgments are reported. So only your personal characters and your family background may be only subjective. Otherwise, all the other aspects of suitability are also can be tested on objective material. So if that judicial review of the decision is permitted to be questioned, is then possibly I think that it will improve the current system, because today it is impossible to challenge.
Right. But in this situation, wouldn't it be the judiciary itself sitting in review of its own decisions in a way?
Right, right. But there are large number of cases where administrative decisions taken by full court or judges of the High Court or Supreme Court have been turned down on judicial side. So I am quite hopeful that when it is posted before a bench on judicial side, they would act independently, because collegium system has a very, I would always say that uh, earlier system was a recommendation by Chief Justice. So what would you prefer, arbitrariness of one person or politics of five? It is for us to choose. So I think that arbitrariness of one person would be ideal, because politics of five will be very dangerous.
In chapter 11, you go through an unpleasant interaction with a particular judge. Afterwards, you wrote an article for All India Reporter titled, "How is a Judge Expected to Conduct Himself in the Temple of Justice?" And very recently, controversy broke out at the Gujarat High Court over interactions with another judge, who this time is the Chief Justice, Sunita Agarwal, and the person and the lawyer before her was the current president of the Gujarat High Court Advocates Association. What are your thoughts on the incident? Could the judge and the bar have handled it better, in your opinion?
I think everybody owes a responsibility to be courteous and respectful to each other. Even if a judge is in power, he is supposed to maintain full decorum and dignity of lawyers. And lawyers are also supposed to, because in certain judgments, it is said that maintenance of dignity is not one way. It is both way. You always say that you are an officer of the court. So being officer of the court, we are supposed to be respectful to the bench. And judges have also same reciprocal obligation to treat every lawyer, maybe a junior lawyer or senior lawyer, with dignity. That is a most fundamental aspect of the judicial system, and it should not be compromised in any circumstances.
You've also spoken about the bar's support for certain judges. Once in the case of Justice Akhil Qureshi against his non-elevation to the Supreme Court, and more recently against the proposed transfer of Justice Nikhil Kariel.
Right.
What impact do you think such protests from the bar have in general?
I think at least one protest has given a very good result, that is against the transfer of Honorable Justice Kariel, because the bar was almost unanimous. He is a very relief-oriented judge and a very good judge, and he would try to do justice within the four corners of law. So everybody was very surprised and shocked to know that he is being transferred. And the reasons, we don't know what were the reasons, but it seems that somebody was displeased by one matter where matter was remanded from the Supreme Court, and he again delivered the same judgment. So that has probably resulted in his transfer. Somebody has probably misrepresented to the collegium that this judge needs to be transferred. And the way of protest which we resorted to was a very unique. We just gathered in the first court, and the first court was full of lawyers. And then we simply went there and just observed 2 minutes silence. And when Chief Justice asked, "Why are you here?" we said that we think that there is a death of independence of judiciary. And that was sufficient to convey the message. And thereafter, the transfer has not taken place. So that's a very good thing. Probably the Supreme Court also realized that because of some misrepresentation, that honorable judge was sought to be transferred. So that's a good thing. But so far as the protest against non-elevation of Honorable Justice Qureshi and non-elevation of Justice G Patel as Chief Justice, that has not given any result. And I don't think, I think that unless all these matters are made subject to judicial review, like transfer of judges, I was actually inspired to file petition because of the Supreme Court judgment in Sakalchand State's case, because in that case, High Court judge was transferred from Gujarat to Andhra Pradesh High Court. And in 1977, he challenged the transfer. And entire law was laid down by the Honorable Supreme Court of India with regard to transfer, how it is to be made, who is to be consulted, Chief Justice of that court, this court, Supreme Court, etc. So only when such persons come forward and challenge the system, the law will be laid down. Otherwise, if nobody dares to challenge such an illegal action, because I think it was a direct outcome of the bold stand taken by Justice Sakal Chand said during the emergency period. So he was sought to be transferred, but when matter went before the Supreme Court, by that time, I think there was some settlement and he was possibly brought back to Gujarat High Court. But the Supreme Court, despite the legal issue being already resolved, deemed it appropriate to decide the controversy, that this is a very important thing and it should be decided on constitutional principles. So unless and until somebody takes a decision to question something, there will not be any law.
Right. And quite recently, I think just a few months ago, you called for a general meeting of the GHCA to discuss sudden changes to the roster after Justice Sandeep Bhatt's roster was changed. What do these sudden changes indicate?
I think, again, it may be a case of misrepresentation by someone who did not like how Justice Sandeep Bhatt dealt with certain cases. And on account of that, only one roster is changed. That is objectionable. One can understand that if entire roster is changed, ultimately, Chief Justice is the master of the roster. That has been laid down in state of Rajasthan versus Prakashan long back. That you cannot question. Somebody has to be entrusted work of allotment. But then that allotment has to be on fair principles. It should not be vindictive. And somebody should not be just sidelined.
Right.
So if somebody is doing good, but if you don't like, you cannot ask him to sit in a division bench and make him redundant.
Right.
So that thing happened recently, and therefore I just wrote a letter. I deemed it appropriate to bring it to the notice of all concerned that this kind of things, if is tolerated, it would not be conducive for rule of law.
Right. There are several other issues from the book. I can tell that there are several other issues which have become sort of personal projects for you. Your criticism of the senior designation system seems to be chief among them. I don't need to point out, but you yourself are a senior advocate. But you explain in the book that you are very reluctant to use the tag.
Right.
You describe the issues you see in the system as it stands now after the Indira Jaising judgment. And you also said that you hope that this division of advocates will be brought to an end. Could you explain that a little further, please?
Actually, nobody goes to the root. This system of designation of senior advocate, it was in fact not designation, it was simple recognition, was initiated by Bombay Bar Association original side before the independence. It was a voluntary kind of recognition. And the main problem was that in those days also the juniors were not getting brief and it was difficult for them to sustain in the profession. So some seniors decided that henceforth we would not appear in the petty cases. We will not file vakalatnama. Rather than we will take help of some juniors who he also earned and he could survive. So with that intention, the voluntary recognition of senior advocate system was evolved. And that has become so he would be placed on an imaginary role of senior advocate and he will not directly interact with the clients. He will keep a junior. He will not appear in petty cases, small cases. He will not do mentioning, etc. And most importantly, he will part with some of his fees with the junior so that a junior can sustain in the profession. So with these avowed objectives, the system was introduced. And when the first law commission in its 14th report, Mr. Setalvad gave his report. He simply compared the system with the Queen's Counsel system, which is absolutely improper. And again, Mr. Setalvad has not examined the system of designation by studying Article 14, 18, and 21. He has simply made recommendation on the basis of empiric study. He went to certain bar association, asked that whether this kind of system is workable or not workable. Because in 1954, I forgot to point out that this voluntary recognition of senior advocate was based on standing of the advocate. But then large number of advocates started being recognized senior advocate. They said that I want to be senior advocate. And they started using the word senior advocate on their visiting card, letterheads, etc. So in 1954, for the first time, Supreme Court amended the Supreme Court rules, whereby the system of recognition became designation by court. So the designation, court conferred designation has a history of only 6 years prior to enactment of Advocates Act 1961. So only 6 years. Prior that, it was purely voluntary. So while making a recommendation, because the 1961 Advocates Act is essentially based on the recommendation of the first Law Commission in its 14th report, which has not studied the provisions of Article 14 and 18, because Article 18 prohibits conferment of distinction other than military and educational distinctions. So this would be a distinction. I do not stretch it to the title. I do not say that it's a title, but it is definitely a distinction which is neither a military distinction nor an educational distinction. So these aspects have not been examined while recommending Section 16. So I am against, because all this I have come to know because of my research. So that is how, and it is actually large number of advocates feel discriminated, and the current system of conferment of designation is most arbitrary in my personal view.
Okay. You were the president of the GHCA, but you resigned from the post after some issues. What was your experience like as president, and what do you think needs to change in the way that bar associations function?
Actually, bar association have become a political adda everywhere. So I was lucky that I was elected twice as president of the Gujarat High Court Advocates Association. But I have different kind of philosophies, and I stick to the rule of law, because at one stage I had to resign because one lawyer was murdered in Jamnagar, not in the court precinct or not in connection with his duty as a lawyer while performing his duties. It was maybe out of some other dispute. He was murdered, and the members of the bar insisted that I should go on strike. Bar should support. So I said that the judgments are otherwise. In those days, the judgment in Krishnakant Tamrakar's case was there, Maipal Singh Rana's case, and uh, Captain Harish Uppal's case were there, which prohibits boycotts and strikes by lawyers. So I resisted, and then the meeting went unruly, and few members just passed a resolution that I am removed from the post of the president. So these kind of things I would not appreciate. And members have political agendas, and everybody wants power. I was not keen on power. I was more on reforms. So Bar Association has a very great responsibility to see that rule of law is maintained, and relations between the bar and bench are also cordial.
Right. You were another issue that you seem to be passionate about is the use of regional languages in courts. So why do you think this has so much opposition from the legal community itself?
See, our mindset is from the day one is like this, that we should encourage English language only. Now, if we examine, there are 4 courts where Hindi is permitted as an additional language, like Madhya Pradesh, Bihar, Rajasthan, and Uttar Pradesh. So in these 3 high courts, Hindi is an official language which has been declared under Article 348, Sub-Article 2 by the concerned state government, governor of that particular state. So if in few states, the local language is permitted to be used in the high court proceedings, why not in other high courts? Because ultimately the system is meant for litigants, and the litigants should be aware of the what is going on, not only outcome. Right now, the Supreme Court, with the help of AI, are translating their judgments into vernacular. But that will not help the system. Nobody is interested in reading the judgment. What is being transpired in the court proceeding, what kind of arguments are raised by the lawyer, what kind of arguments are raised by the opponents, what queries judges put to the lawyers. So it is a participative process where the litigant has stake. He is entitled to know what is happening. He is not simply concerned with the mere outcome. The lawyer will come and say your petition has been dismissed. And now I will give one instance that in medical profession also, whenever you are to be operated, it is mandated that doctor must explain what kind of procedure he will be adopting and what are going to be side effects and what things he has to understand. So that kind of form is also mandatory. So if in that also, and take an example, if you are a patient and if you go to the doctor and doctor simply said that you will have to, I will perform surgery, he will not explain what is what for what reason. That is absolutely improper. Therefore, I am very keen that it should be additional. I am not against English. I have repeatedly said that I love this language. I am fond of English language. But at the same time, there should be accommodation of our regional languages in the High Court proceedings. Supreme Court, a number of peoples are coming from different states. There, right now, time is not right, and English can continue as the only language because in southern part of India, most of the peoples do not understand Hindi. So it would be improper to thrust upon them only one language. So either Hindi or English, but for the time being, English is working satisfactorily. So my views are very clear that it should be permitted at regional level. And
Right.
Supreme Court is not the regular court of appeal because some people argue that High Court proceedings, if somebody wants to go to Supreme Court, then they forget that it is not a court of regular appeal, only by special leave. And those where there is statutory appeal, the translations are being provided by the High Court because the original proceedings like criminal cases, conviction cases, death sentences, where the original proceedings are in regional language, but the High Court do translation and then the record is signed. So only very few cases where it is a regular court of appeal. But otherwise, it is a special leave petition only.
Coming to the end of the interview, really, all your previous books have been on law. You've written about bail, you've written about the rights of arrested persons, excise law, and several other topics that are directly related to the law. So, why this personal story now, and why focus on misadventures and failures of all things?
A very nice question. Actually, this year in this July, I'm turning 60. So I deemed it appropriate to just look back what I have done in my life. So while reflecting on my life, I thought that I have done lots of misadventures and I have failed multiple times. So I just wanted the readers to have smile on their face. It is just a memoir where I have simply mentioned what I have experimented in my life at the personal cost. You will find many episodes where I had to incur lots of rupees on approaching Supreme Court to get my adverse remark expunged, etc., etc. So, just looking back at my life, I found that either you may say that they were very stupid decisions, or maybe they are full of wisdom, divine wisdom, I may say. So I am not sure. Therefore, I thought let future generation know what is happening in the profession. And many people still say that in the past there was no politics. But if we examine in the past, also in 1975, also three Supreme Court judges had resigned because of superseding them and making some junior judges Supreme Court judge. So politics is there in the appointment and making chief justice and transfers. So this book would also serve as a guide for future generation that after 100 years, if somebody wants to see how judicial system worked in year 2025 or before that, this book will be very useful that these things are happening since time immemorial. It is nothing is new. Politics is not a new thing which we are encountering right now for the first time. So these are the reasons. Just I look back and I find that many things which is very interesting and very funny.
Right.
So
Do you have any advice for young lawyers who are probably navigating their own misadventures and failures right now?
Actually, I am not a right person to advise anyone because something which is available free is not valued much. So everybody is willing to give free advice, but I would only say that person should have conviction for his views and he should make full research. And whenever, uh, in his personal view, he thinks that there is an injustice in a particular episode, he should try to see that that injustice is not meted out again, and he makes his best effort to see that things doesn't happen again. So courage is most important, and definitely perseverance and passion for the law is necessary to be a successful lawyer. I am not saying that I am a successful lawyer, but still, to survive in the profession, also this is a very essential thing.
I think many of us would disagree with the not successful part of what you just said, but your insight on all the topics has been extremely valuable. Thank you for taking the time out to speak with us, and I wish you all the very best for the future.
Thank you very much for inviting me and giving me this opportunity to share my views on my book. Thank you very much.